Assalamualaikum warahmatullahi wabarakatuh to Sir Badru. I'm Muhammad Aizzat Iskandar bin MALEK, and today with my partner Noor ASRI Fadli bin KAMAL want to present the answer from the question that have been given by Sir. So for your information, Sir had give us two questions, which are question 1 and question 2. So we choose question 2. And firstly, we will see the question first. And I will show for a few seconds. So now to the question. So this is a question 2. So next, we will go to the answer. So how to answer this question? So firstly, we must identify the issue. So the issue in this situation is to identify whether can or not Hadi make an insurance claim on the house that destroyed by the floods. Because Hadi is the holder of the policy on his old house before that house had been sold to the Hijau Berhad HB. So secondly, give our opinion. So our opinion is, in our opinion, Hadi cannot able to claim the insurance on his old house even though he is the policy holder for that house. It is because Hadi is not anymore the owner of that house next. Natural disaster which is floods that destroyed that house was occurred after Hadi sold it that house to Hijau Berhad HB. So thirdly, in this part, we must give the evidence to support our opinion in second step or part. So now, to support our opinion, there are two sections in the Company Act of 2016 that can be applied to this situation, which are Section 20 and Section 21. So, to begin, we will examine Section 20 of the Company Act 2016, which states that once incorporated, a company becomes a body corporate with a legal personality distinct from that of its member. The doctrine of separate legal entity or the will of incorporation. To be easy understand, we will take one of the case under Section 20 Company Act 2016, which is Solomon versus Solomon and Co. So in this case, Solomon transferred his business of bootmaking initially run as a sole proprietorship to a company, Solomon Limited Company, incorporate with member comprising of himself and his family. The price for such transfer was paid to Solomon by way of share and debenture, having a floating charge security against debt on the asset of the company. Later, when the company's business failed and it went into liquidation, Solomon rights of recovery secured through floating charge against the debentures to appear to the claim of unsecured creditor, who would thus has recover nothing from the liquidation proceed. The liquidator sought to overlook the separate personality of Solomon Limited Company, distinct from its member Solomon, so as to make Solomon personally liable for the company debt as if he continued to conduct the business as a sole trader. And the issue in Solomon case, whether regardless of the separate legal identity of the company, a shareholder or controller could be held liable for its debt over and above the capital contribution, so as to expose such member to unlimited personal liability. The judgment, a company is a separate legal entity distinct from its member, and so is certain Mr. Solomon, the founder of a Solomon and Company, from personal liability to the creditor of the company he founded. The court also upheld firmly the doctrine of corporate personality as set out in the Company Act 1892. Sorry, Company Act 1862. So that creditor of an insolvent company could not sue the company's shareholder to pay up standing debt. So next, we will go to the Section 21 Company Act 2016 that state companies have unlimited capacity to carry on or undertake any business or activity include to acquire, own, hold, develop, or dispose of any property. So, the example case that can be applied or used to be evident in case Hadi is Kaura versus Northern Assurance Co. In this case, the owner of a timber estate sold all the timber to a company which was owned almost solely by him. He was the company's largest creditor. He insured the timber against fire but in his own name. After the timber was destroyed by fire, the insurance company refused to I will repeat again. After the timber was destroyed by the fire, the insurance company refused the claim. The House of Lords The House of Lords held that in order to have an insurable interest in property, a person must have a legal or equitable interest in that property. The claim failed as the corporate, even if he owed all the share is not corporation. Neither he nor any creditor of the company has any property legal or equitable in the asset of the corporation. So that's all from me, and this presentation or slide will be continued by No Asri Fadli bin Kamal. So thank you.
Assalamualaikum warahmatullahi wabarakatuh. Thank you, Aizzat, for the presentation. Before I start the presentation, I will introduce myself. My name is Nur Asifadli bin Kamal, and now I will discuss the answer about the application of the law and conclusion about this case. Okay. The application of the law as an application, Section 20 of the Companies Act of 2019 states that the company and the member are two distinct entities. Even Taf Hadi is the sole shareholder and director of Hijau Berhad HB. He is unable to use his authority to resolve this issue because Hadi's problem is his privacy problem and work is work. As the professional worker, Hadi already know that he can combine his privacy and his work. Hadi is not entitled to claim insurance for his old house under Section 31 of the Companies Act because he is not the owner of that flood house. Now that Hijau Berhad HB is the new owner of that house, HB has complete control over it. So Hadi, as a member, cannot claim his old house under his care. Okay. Finally, the conclusion. In conclusion, Hadi is not entitled to make a claim on his old house insurance because that house was already purchased by Hijau Berhad HB and HB is the new owners of that flood house. Therefore, Hadi is the director of Hijau Berhad, has no interest in company property because he is not the owner of that house. So, that's all for me. Thank you.